procedural questions, I need to grab my rule book, however, which I left on my desk, so I'll be back in about 10 seconds. Okay, and as to the motion for reconsideration, of course, it has to do with Civil Rule 59, and there's a few aspects of Civil Rule 59 that I just want to make a record of. Number one has to do with CR 59C. It says the opposing party has 10 days after service to file opposing affidavits. So there's a different time frame for motions for reconsideration, and that's 10 days. The other aspect is, if you take a look at 59E, it says when a motion for reconsideration or for a new trial is filed, the judge by whom it is to be heard may, on the judge's own motion or on the application, in this case it's on the application because there was a motion, but the judge is to set the time of the hearing and address those other matters. So my question is whether or not, Mr. Bolt, you're prepared to go forward on the motion for reconsideration today.
Yes, we are, Your Honor.
Okay, all right. Having reviewed that, let's go ahead and proceed then. And any preliminary matters before we begin?
Your Honor, it would seem procedurally that we would first need to deal with the presentation decision on the motion to compel, and then the motion to reconsider that.
Yes, I agree.
Okay.
And so, as far as the presentation, and let me grab it. I do have the order first, and this is prepared by the office of Mr. Gates, signed by Ms. White. And any comment, again, Ms. White would typically send that to you for your review. And did you review it, Mr. Bolt?
Your Honor, I looked at the proposed order from Ms. White, and then we also submitted a proposed order from the respondent on that motion to compel.
All right. So
have that?
Yes, but as to Ms. White's proposed orders on the motion to compel, do you feel like that adequately memorializes the court's decision?
No, Your Honor. I note on the transcript that was made on page 8, line 15, the court is saying, quote, at this time, I'm just denying the motion, end quote. And in line with that, the order that we propose to memorialize that decision is very simple, short, and straightforward. And it just says that the motion is denied. The opposing counsel's version of that included some things that don't really need to be there, such as that the motion was not filed in bad faith, and that the court lacks certain information. I know that commonly the court, in announcing an oral decision, will make express preferences or partial reasons and dicta and things like that that are not really the ruling. In addition, the print on the page is misleading, to say the least. I think it's just wrong. It says they're ordered to compel discovery. And of course, that's not what it was. It was an order denying a motion to compel discovery. So I think that the more accurate and succinct and correct a reflection of the court's ruling is in the proposed order that is before the court and we sent to council.
All right. And Ms. White, what I've done, I've used your order as a template, and thank you, Mr. Bolt, for your comments, but I've just changed order RE motion to compel discovery. And so paragraph 1, I've left the same. Paragraph 2, the same. Paragraph 3, the same. Paragraph 4, the same. And I've signed off on the order. Okay. Now, regarding reconsideration, your motion, Ms. White, go ahead.
Thank you, Your Honor. Yes, Your Honor. At the time of our last hearing, it was clear that the documents that were before the court were not sufficient for the court to give a full consideration of petitioner's request to compel discovery, and I interpreted the court's ruling to indicate essentially an invitation to supplement the court record so the court could have a more full record to do additional consideration of evaluation of the interrogatories and consideration of petitioner's motion to compel the respondent to fully comply with, most particularly, the request for production under request for production B, i.e. the bank records. And so I have filed, in good faith, a motion for reconsideration asking the court to reconsider its prior decision, giving full review of the interrogatories and the answers to the interrogatories that I've supplemented the record with prior to today's hearing. Those were filed with the court and served on the other party last week. As the court knows, under CR 59, there is no prohibition in that rule from supplementing the record, unlike Local Court Rule 53.2, a revision, which specifically states that a motion for revision shall be heard upon the record that was before the court commissioner. This is not a revision action. This is a reconsideration action. The commissioner can and should consider any supplemental information that has been supplied to the court for consideration, so as to make a ruling that is fully informed on this issue. I made arguments last time about why the court should give our motion to compel consideration and to grant it. I noticed in Mr. Bolt's response to my motion for reconsideration that he indicates there is no substantive issue here before the court. There's no injustice here for the court to address under 59A9. Substantial justice has not been done. The fact of the matter is that under CR 26, the parties are authorized and given the approval to obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action. The respondent's bank records are definitely relevant. They're not privileged. And we were authorized to have discovery of that. There have been significant games played in responding to petitioners' interrogatories. First of all, there was significant delays in having the CR 26I conference, so I couldn't even get before the court early in October to address any shortcomings. And then there were significant delays even after the agreed upon date to receive those answers to those interrogatories. I did not receive answers until October 28th, 2 days before the cutoff date for any supplemental discovery I could have asked for. And on that same date that I received them, I sent clarifying information to Mr. Bolt saying I didn't get full answers on this discovery request, and I didn't get any response. So I think that it's a substantial injustice to allow the respondent to hide records from the petitioner that are potentially critical to her being able to adequately prepare and present her case to the court. I'm not quite sure what we're hiding in the bank records, if there's income or whatever there, but for some reason, there's a pretty significant fight or resistance to providing discovery that we're absolutely authorized to receive. I would also note that the court has the authority under 20 CR 26, let me get the number, EB3 to order the other side to supplement the responses anytime prior to trial. So I'm asking the court to order the respondent to supplement his responses to his interrogatories, to require him to provide the bank records that we requested, to say that those commas were just in the request were just expanding upon the term business records would fly in the face of the way the rest of the interrogatories were written. If I had intended for it to be just bank records or business records, I would have said business records, including, and then listed bank records, receipts, so forth and so on. I didn't do that. I listed each item with a comma in between them. They're separate items. I expected them to each be complied with. You can see by request C, which is right under request B, that's exactly what I did. I wanted the 2019 tax return, comma, including all worksheets and attachments, which, by the way, we really didn't get fully there either, but I had enough to work with. If I had intended for B to be read the way that Mr. Bolton insists that it be read, I would have said copies of all business records, including bank receipts, bank statements, contracts, etc. I didn't do that. And I didn't receive a response within 30 days as required by CR 34-3A. Had that been done, I would have had time to file supplemental request. I would have had time to seek authorization from the court to compel it. There's just been a lot of feet dragging, game playing, and so forth. With respect to, and I can go through a number of other questions in the interrogatories that are very similar, that include language that says including. I'm not going to waste the court's time with that today. You have the interrogatories, you can see them. With respect to attorney fees, it's pretty rich to be asking the court to order 2609-140 attorney fees when the court to do that needs to be looking at the financial capabilities of the parties to cover the other parties' attorney fees. And as we all know, Mr. Bolt's client, it makes in excess of $100,000 a year, and my client is in school. So the financial resources of my client are not sufficient enough to support paying attorney fees for Mr. Bolt's client. Additionally, under a CR11 sanction, I don't believe CR11 sanctions are justified in this case. I think I have a colorable claim to ask the court to reconsider, particularly given the court's language in the transcript, which I've provided to the court and to Mr. Bolt, indicating that at this time, the court didn't have sufficient information. I've provided the supplemental information, and I think at this time the court does have the information necessary to make a decision on this matter. I did not go file this under the provision under CR 59 that would say that there was surprise information or anything like that, because that would have been a CR 11 sanctionable event. I never claimed that. I've always claimed I have the information. I failed to provide it. I've supplemented the court record now, and I'm asking the court to consider it. And I'm asking the court to
Any person who
compel
wanted to do that, could they make
Mr. Combs
devise their
to
own fake
supply the
background?
bank records and also award attorney fees for having to ask for Mr. Combs to comply with my discovery request. Thank you, Your Honor.
Including puppies.
And one question, Ms. White, how's the court to view CR 59A4 when a ground for reconsideration is listed, which is newly discovered evidence, material for the party making the application, which was your client, which he could not have with reasonable diligence have discovered and produced at the trial. In this case, it's a motion. How is the court to consider that since, of course, and you know, it's clear that the necessary information could have been filed at the time of the hearing, but wasn't.
Well, the court says that such motions may be granted for any of the following causes materially affecting the substantial rights of the parties. And under 9, it's the substantial justice has not been done. And substantial justice has not been done here. My client has been denied full discovery in this case.
Okay. All right. Well, Mr. Bolt, the other side of that is what Ms. White could have done is instead of a reconsideration, refiled her motion, you know, after another 26I conference. And, you know, we could be in the same place in 2 weeks. Rather than that, she filed what I didn't have at the last hearing and is asking the court to proceed. I understand your pleadings and why you object to it, but aren't we going to be in the same place 2 weeks from now if she chooses that route?
Your Honor, opposing counsel is attempting to get a second bite of the apple here. If you have a motion and it comes before the court and you have every opportunity to provide whatever evidence you have to support it, which she did not do for that motion to compel, and the court denies the motion, then absent one of the CR 59A grounds, that's the end of it. You don't get to come back and have a do-over. There's no provision in the law for that. We're here now on a motion for reconsideration. Counsel used some pretty strong language there, such as game playing, and I think the only game playing has been on the part of the petitioner. What we have, counsel said that she considered the court's ruling to invite her to supplement the record. Well, that's all in her own mind. The court did not say that. It's not in the transcript. There was nothing like that mentioned. She limited her motion for reconsideration to CR 59A9, and the requirements for that are very high. In fact, she cited no case to support it, and in fact, there is no case since appellate decisions started being published in 1890. There's never been a case, appellate reported case, where an appellate court has said that a trial court decision denying a motion to compel meant that there was a CR 59A9 substantial injustice claim. It's never happened, and she's asking apparently the court to be the first. But there's been cases where the appellants have made claims like that, and they have all been denied. She's attempting to put new evidence before the court, and the decisions we've cited make clear that the only grounds to do that is the one that the court just mentioned, which was the CR 59A4. And that doesn't fly because it was not newly discovered evidence. She obviously had that long before and simply didn't put it in there. And there's no grounds for a CR 59A4 or any other CR 59, and certainly not CR A9, the appellant tried that in that Sleegar case that we mentioned, Sleegar v. Odell, tried to use a substantial justice argument there, and the court said, no, you can't do that. You could have presented the evidence you used to support the motion for reconsideration in the substantive motion that underlined it. You didn't do that. It's too late. There's no way to do that. There were 32 interrogatories, 7 requests for production. Counsel seems to be giving almost all of her attention to what is really interrogatory number 6. And she says in there that it wasn't limited to business records, but if we actually look at it, it says she's asking there for copies of all business records, receipts, bank statements, contract, and expense record for the past 24 months. It's preceded by business records. And I think I used this analogy or something similar last time, but it's kind of like if you said, I want you to list all of your female family members, friends, and work colleagues. Well, you would assume that that meant female family members, female work colleagues, and female family members. Or if you said, I want you to produce all of the pre-Civil War clothes, military artifacts, and diaries, you would assume that pre-Civil War meant applying to each of those subsequent terms. And that's the way the question was phrased, and that's the way that my client answered it. He answered it correctly. He answered it fully, and the fact is that he has no such business records, and we've told her that in a supplemental response to make it even more clear that that's the position we have there. So at this point, there's really nothing to compel. She may wish that she had asked some other different kind of question. She might have a second round of discovery, I suppose, just like any party might, but and then that would be up to her to try to do. But there's no grounds for, there's no admissible evidence to support this motion. There's no legal grounds to support the motion. There's no logical grounds to support the motion. And there's nothing left to compel. Mr. Combs has answered the question that was actually posed. And it's the question that's posed that counts. It's not the question that opposing counsel wishes she had asked. So there's 0 grounds for this motion for reconsideration. We've demonstrated that in the memorandum. Opposing counsel didn't cite a single case either before or after that to the contrary, and there is no case. It's just a groundless motion. So my client should not be the one to bear the expense of responding to this motion that is completely baseless as a motion for reconsideration.
Okay, Ms. White, you have 2 more minutes.
Thank you. Thank you, Your Honor. Again, there was an assumption made apparently by Mr. Combs. I clarified in my immediate email back to them that that assumption was incorrect. I asked them to answer the question that I wrote. I did not say business records, including, and then list those items. Each one was separated by a comment. I intended for each one to stand on its own, and I informed them of that. They did not comply with it. With respect to no appellate court action, well, because under reconsideration, the court can consider supplemental documentation. There's nothing that prohibits the court from doing that. And I asked the court to rule in my favor and to compel discovery and to reconsider its prior denial of that motion to compel. Thank you, Your Honor. And by the way, Your Honor, I did not have time to file supplemental discovery requests. As I said, they delayed responding to my discovery request significantly after its due date, almost a full month later, knowing that I was up against a discovery cutoff date of the 30th of October. So 2 days before that, then I finally get incomplete discovery request answers. So,
okay.
Your Honor, thank you.
All right, and this is case number 19-3174-23, Combs and Combs. The court previously signed the order regarding the motion to compel, and it comes back for a motion for reconsideration with new evidence. And there is new evidence, that's true. And before I get to the assessment of the new evidence, I need to decide whether or not under CR 59, reconsideration is appropriate today. And that is the question that I'll decide first. And the court is asked to find that substantial justice has not been done in the case. And frankly, I can't do that. I can't find that substantial justice has not been done. I don't have a basis for that finding. This is a case where there was a motion. The court looked at what was before it at the time of the motion, and I just did not have sufficient information to find in favor of the moving party. Clearly, under CR 59A4, if there was newly discovered evidence, then that would be another issue. And candidly, Ms. White is saying this is not newly discovered evidence. And so the court, again, does not have a basis that substantial justice has not been done. So I'm going to deny reconsideration. The next question is whether or not under CR 11, it's sanctionable. I'm going to find that it's not. I'm not going to award attorney's fees for this, either under CR 11 or RCW 2609-140. And the court will find that this, although maybe not supported by appellate decisions, that this is not done in bad faith, and it is not a, well, I'll just leave it right there. Okay, that's going to be the order of the court today. Thank you.
Thank you, Your Honor.